Morning, everyone. Welcome to the fortnightly IAB Australia webinar. Thank you for all joining us. I think we'll have a few people joining us in a few minutes. I know this is now a conflict time with Gladys's update each morning, so we'll let you know the numbers. I'm sure you're all getting at news alerts as well, but we've got a lot to get through today. And some amazingly smart and friendly guests. We don't always get both, but we've got both today. So, and a fascinating topic. So this is, I think, the 45th IAB Australia webinar since the original lockdown. So we've pretty much got most areas covered. Tiff, who's in the background running the magic of the webinar, will share a link to the archive of all those webinars. So if you're looking for anything, please have a look there. If we haven't covered something that you're interested in hearing about, let us know as well, and we'll put that into the program going forward. So today we're going to talk privacy, and it's been triggered, I guess, for a couple of reasons, this talk. The IAB in the US have undergone an amazing project that we're going to hear about today that's looking at privacy laws across 11 different regions across the globe. Often the IAB, locally and globally, we often have quite separate conversations from a tech and privacy point of view. What I love about this project is it's bringing those two worlds together, and we'll hear a bit more about that going forward. So we've got, as I said, some wonderful guests lined up for you today. The way we're going to run the hour, I'm going to have an initial fireside chat with Michael Hahn, who's the SVP and General Counsel for IAB in the US, commonly just known as the IAB, which is a bit rude. We probably should call it the IAB US. And then we're going to be joined by a couple of local experts who have worked on this amazing piece of work that's coming out of the US, Sophie Dawson from Bird & Bird and Alex Hutchins from McCullough Robertson. And also from IAB Tech Lab, Alex Cohn, who some of you may have seen on previous IAB Australian webinars, is joining us again. And we'll come in both from a data governance point of view, but how we can make this actually operate as an industry changes in privacy laws around the world. So the document, I guess it's a project or a document we're talking about today, cross-jurisdiction privacy project, is a approximately 500 to 600 page document, which is going to land on the IAB US website tomorrow, and with clear guidance, and we'll talk through with Michael in a minute exactly what it's going to go through, but clear guidance on privacy legislation across the different regions in the world, which will be an amazing resource. And today we'll try and summarize it, and I'm sure we'll have, after the document's released, more information for the local market, how it can be used, and some more information there. So on that note, let me welcome Michael, and we'll have a bit of chat.
Well, thank you so much for having me here today and presenting the opportunity to speak with your organization and its members.
Absolute pleasure, and thanks for staying up a little late for us, or working a little late for us to join us.
Happy to.
First up, what is this beast that you've built, Michael, and I guess why?
Yeah, well, so the cross-jurisdiction privacy project was really designed to solve for two different issues that we brought together under one roof. And the first one is when you go into a general counsel's office of some of our global members, they find it many times incredibly challenging managing a multi-jurisdictional approach to privacy across a number of regions with sometimes different sets of principles, different sets of rules, different length and history of how long the law has been in effect for, and different levels of knowledge among the council that they work with, and oftentimes even just a common baseline about how these laws apply in the digital ad ecosystem. And so oftentimes they're just entirely dependent on hearing some sort of truncated narrative and some very important questions that they need answered. And so we decided to look at 11 different jurisdictions across the globe and put together a document that would summarize not only the privacy laws, but also talk about their application in the digital advertising industry. So we came up with a template of the hard questions that all of the chief privacy officers want answers to when they're thinking about compliance in a jurisdiction which they don't have expertise themselves. And it becomes a tremendous baseline of knowledge for them to be having the right kind of dialogue with their local counsel to achieve compliance. So when I think about, what does a general counsel want to know? When there's a pixel on a publisher's page, who has a responsibility to the consumer? Is it the publisher? Is it the ad tech company? Is it both of them together? When I have synonymous information sitting in a database, is it personal information if I can hire a service provider to render it first-party information, but I choose not to do it? I want to know the answer to that question. By the way, the answer we learned is very different across these different jurisdictions to questions like these. So what we've done is put that sort of framework in place for the Compendium, which will be published tomorrow. And so this becomes a real practical tool really for every privacy lawyer who has any sort of global footprint. Additionally, we saw something happen when our organization was helping our members prepare for CCPA in California. And so there was an extraordinary challenge because it was a very short period of time to prepare for that law. And the technical build was a big challenge for many members. And you had a build that was done to TCF in Europe. Then there was a build to the US privacy string in California. And I think a lot of people said, and the engineers certainly told their lawyers this, that this is not an efficient way to go, to just keep building one country after another in sort of separate builds. And you'll hear more today from Alex Cohn from the IAB Tech Lab about some of what drove this. So the notion then became, okay, we're going to build something that can be broader and encompass a lot of different jurisdictions. But there need to be, as we did in California, the lawyers had to give the information that the engineers would use to fill the signals about what to communicate to make a transaction lawfully processed. And so we've actually done that in this process across these 11 jurisdictions. So those are really the two things that we tried solving for. And so that's our work product.
A question from me that I haven't prepared you for, but off the back of that, how clean was that getting the answer for each jurisdiction on I guess, the interpretation of the law, that you could feel confident that what you're building was actually fit for purpose?
Yeah, great question. So we spent a year doing this. And so some questions have clear answers. Some questions have clear answers in some jurisdictions and some not in others. We had a couple of baseline rules in this exercise, which I think answers your question. One rule was that we are not making judgments and saying where we think the law ought to go. We're not making judgments about what we think the correct interpretation of the law is. Clearly, if the statute or the enforcement authority has rendered a decision in a particular application, then it's clear, and we state it that way. But if it's not, we don't try to persuade anybody. What we do is try to give the best picture of the law as we understand it. And in the absence of clarity, we say that there's ambiguity. But here's how the market participants, to our understanding, are responding to that lack of clarity in the digital ad ecosystem. And so we try to give a clear picture that way. And we really have been helped along the way. We had 150 lawyers around the globe working on this. And so we could not have done this without the wise counsel that we received from our local law firm partners in Australia that included Alex and Sophie.
Awesome. So I guess you've told us why and a little bit, I guess, a hint of how people would use it, but could you go into a bit more detail in terms of it as a tool? How do you expect people to actually use the compendium?
Yeah, so the compendium we expect is probably going to be used in a couple ways. So again, one is if you're a global company with a different footprint, every time you're thinking about compliance in a jurisdiction, and where do I begin? How do I sort through these issues? This really helps you through that. But I would also say it helps even local lawyers deal with some of this stuff too. It's pretty complicated, and so one of the things that I think that the folks who are involved in drafting the compendium had as a big advantage is that everyone involved really understood the digital advertising ecosystem well, and so there's a lot to be learned in reading through these applications of the privacy law, even among local attorneys. So I think this kind of helps everyone up level their game, as the phrase goes. In terms of the our phase 2 work product, which is this legal specifications chart, which I'll share with all of you in a moment. Again, this is going to be used by the Tech Lab to help create the global privacy string, which will allow parties to communicate privacy preferences. And we can talk some more about how that can be done with a policy, without a policy, a lot to get into there. But the chart itself, once you understand how it's created and for what purpose, is an incredible reference tool. And that can be used by attorneys. And so I'll share my screen so that you all have a sense of what it is we've done with our phase 2 project here. So this is our legal specification chart, and we cover the 11 jurisdictions, and we go across and we cover a lot of different purposes. So I'm going to jump to one of the tabs. We have a glossary, of course, that defines things like consent and implied consent, opt-out, what we mean in the chart by required and permitted and not permitted. And some of those definitions are really critical to understanding how this chart is designed, because it's the number one audience in this was the Tech Lab. So just because it says required and permitted, you really need to read these definitions. But what we've done, which is, I think, in many ways, I'll call it partially novel, right? The TCF is something that so much of the industry has been built to. Yet, at the same time, the TCF requires, because it's meeting GDPR's particular requirements, a whole lot more specificity than is required in most places around the globe. And even from a consumer standpoint, might break things down more than you necessarily want or need to. So what we tried to come up with were, 5 sensible buckets for purposes. And those purposes do tie to TCF's more detailed purposes. So looking at advertising and content purposes here, it actually ties to TCF purposes 2, 3, 4, 5, 6, and special purpose 2, kind of like it bundles them together. And we also have measurement, research, and reporting. We have special categories of data. Ooh, I think I just lost my link. We have special methods of processing, and then we have internal uses. So then if you go to a jurisdiction, and so we're in Australia here. So let's just take a look for simplicity purposes. We go to lines 6 here. It's measurement, research, and reporting purposes. And so what we're saying under the current law, that for measurement, research, and reporting, you need to disclose to the consumer through a privacy policy that you're going to be using it for this purpose. Whether you put it in an explicit notice, such as a cookie banner, is something that is optional. With respect to third parties, there's this issue in Europe, for example, you need to identify the actual third parties who are receiving the information. Most other places in the world are fine with categories of third parties. And so here, under your privacy law, either one of those methods are permissible, as we indicate here, of the disclosure of who the third parties are to the consumer, whether it's categories or identifying them. And then we get into the conditions of processing. Are we talking about consent, implied consent, opt-out, legitimate interest? These are all, umbrellas terms that are used across all the 11 jurisdictions in some fashion. And so what we're saying here is that how you satisfy the requirement is, you can use consent, it's optional, whether it's implied consent is optional, or even opt-out is optional. Again, there's definitions to all of these things. So for example, there's a definition optional, which means a basis for processing or a disclosure item is optional if there's no legal requirement to satisfy or provide, but a framework participant may wish to signal that they have provided for market, contractual, or other reasons. So, that's what I'm saying. There's kind of pretty detailed nuance.
That's great. So that people can.
So that's the nature of the chart. And so you can imagine across all these jurisdictions, in particular, if you're working across different jurisdictions, that's going to be really helpful. But it's also just important to know that this rebucketing, I'll call it, of the purposes into 5 buckets. And with additional breakdowns where necessary. So there might be a general bucket for advertising purposes, and I believe this was the case for Australia, that there might be certain instances where you need to provide a more detailed notice on a particular use case, right? And you might need to treat it differently. You might have a consent or some other requirement around it. And so we specify that. But the concept, though, of these 5 buckets, if we begin to integrate this into the tech over time and integrate it ultimately with local policy, you'll get to a place where you'll see some common methods being used across the globe.
That's great. I mean, it's brilliant for building out the tech, but it's also just an amazing handy resource to quickly check what can and can't be done. It's much quicker way than trying to trawl through a whole lot of other bits and pieces. 2 quick questions, Michael. You're the lucky chap who's had the benefit of sort of that overview of all the different pieces coming in, all the different countries' legislation coming through. I think in Australia, when we hear about privacy reform, we immediately jump to GDPR, and we jump to most of the things that are being developed in other markets are GDPR-like, possibly to the exception of California. Firstly, is that an accurate reflection of what's happening around the world? And then my second question is a bit like pick your favorite child, and this can be completely subjective because I know we're not influencing policymakers here, but are there any areas, any regions that have particularly impressed you with their approach to reform?
Yeah, it's a great question. I think if you asked most privacy lawyers what the trend is around the globe, they'd all say, oh, it's GDPR. But once you start studying a lot of the different laws, you begin to realize that the answer is really a lot more nuanced than that. I would say that many of the newer privacy laws are inspired by GDPR, but don't necessarily tread the exact same pathway as GDPR. There are certain elements that you'll find in commonality, but you'll also find departures as well, with local jurisdictions making some of their own policy choices in that process. And I do think that that's a healthy thing. There's a lot to be learned from GDPR, right? It was the first very large geographic area that covered privacy law in a new, more pointed way, and created new sets of rights that didn't exist before. And how you balance those, consumer benefits and the business imposition is something that we're going to be learning from years. And I do think, as I look at other jurisdictions around the world, I do see some of that learning process happen. And I guess I was quite impressed by what I saw in Singapore's amendment to its privacy law in 2020 in the PDPA. There in that amendment, there were, of course, some of the important elements about strengthening accountability, enhancing a legal framework for collection, use, and disclosure of data, enhancing some of the enforcement tools of the regulators, and also providing some greater autonomy for individuals. But they did a real balancing, which I think is critical. And as I think about some of our experiences in CCPA, even, which I'm obviously most familiar with, right? We provided, just as an example, rights to access. The access right, when we took a survey of our members, it's infinitesimally small, the number of access requests our members get. Someone needs to probably say, is there anything to learn from that? To say, like, is the business cost worth it if consumers aren't really interested in doing that? And so I see a lot of those pieces. So when I looked at the PDPA, and I saw, wow, they actually made an exception for business contact data. That seems like a real balancing. And actually, even in the definition of personal information in and of itself, it goes away from both the GDPR and the CCPA direction of necessarily hard coding in what constitutes personal information. So, for example, IP address is not automatically personal information, like other statutes that you have experience with outside of privacy, where there's a balancing test. What's the purpose of the information? Can the individuals be identified when it's combined with other information? How many elements are there in the data set? What's the nature of the data? So there are a lot of things that I think are positive that are happening in different parts of the globe to try to find the right balance.
Perfect. We might, on that note, bring everyone else into the conversation, because I'm sure Michael could talk all day on this, which would be fabulous. I might first chat to both Alex H. and Sophie in terms of, I guess, the Australian sort of story at the moment. And as we know, there is reform coming, but at the moment we're still with our current sort of privacy regime, and it's probably a while off, and I might get your opinions on that, how far off that reform is in amongst it as well. But maybe, Alex, if we start with you, in terms of today, talking particularly to people in our audience that are more from the commercial side, maybe not deep in the law, can you just give a quick overview of what sort of notice is required in the Australian market today?
Yeah, sure thing. And look, obviously what we're about to talk about assumes that when in the digital ecosystem you are handling personal information, because that's the touchstone of our Privacy Act. We can unpack that a little bit further, because that's one of the key issues we found in Australia. And Michael, we came back to the same refrain every time. I think there was a lot of frustration about really trying to nail that down. But so very quickly, we have a Federal Privacy Act. It has 13 Australian privacy principles. A couple of them are particularly relevant in the context of providing notice. So we have Australian Privacy Principle 5, which says that anyone who is collecting personal information needs to take reasonable steps to notify the individual of certain things. And thank you for whoever's just shared that slide. So APP 5 is the one we're talking about. And so there are certain things that you need to ensure the individual is aware of, and that's the fact of collection to begin with. Who is it? Who's the entity who's collected that information? What are their contact details? Whether that collection was authorised by law, who that information might be disclosed to, which is crucial, whether it's disclosed overseas, and if so, which countries. There are some others, but they're kind of the key ones. And so that requires notice. There is a sort of notice requirement so people understand what's happening with their information. And this dovetails very closely with APP 7 direct marketing, which is listed there as well, because it's prohibited to use personal information for direct marketing, and all of the sort of digital advertising activities are very clearly direct marketing. You can't do that unless you've satisfied certain requirements, and that in turn requires either that the individual be reasonably aware or reasonably expect that their information will be used for direct marketing. So providing notice under APP 5 is one way that you can discharge that obligation to make them reasonably aware. Or in circumstances where there's a party down the line who doesn't have a direct relationship with the individual, there's a separate section of APP 7 which sort of says, well, if you don't have that relationship, another way you can establish a legitimate reason for, or a permitted reason for undertaking direct marketing is if there is consent. So you've got that sort of fundamentally a notice and consent regime which can apply differently in different circumstances and to different parties, but that's essentially what you come back to. And then we deal with sort of through the life cycle, individuals always have the opportunity to opt out of that kind of activity using their information, or if they've provided consent, touchstone of consent is, of course, that you can withdraw it. And so there's mechanisms around that. And so we need tools to be able to manage that notice and consent regime through the supply chain. And so that's really where the string becomes important, because there are all sorts of variables about how you can satisfy those requirements.
Thank you for that. And I did meant to say to the audience, we will try and get time for questions at the end. So please pop anything into the Q&A. And if there's anything just too lengthy to deal with in the webinar, we'll try and publish something later. But Sophie, who's created this wonderful deck, has relented that she will share this with the audience. So we'll send a link to the recording and to this deck early next week. Sophie, can I get you to follow on from Alex in terms of, we've heard, I guess, a little bit about what's necessary today, but on the PII journey here in the market in Australia, and we've heard from Michael, there's, obviously very different interpretation of PII. Where are we on that currently? And any, I guess, crystal gazing in terms of where do you think we might end up in sort of the near distant future?
Thank you, Gay. And before I forget, I'd just like to acknowledge the role that James Hoy on our team also had in this project, because he did an enormous amount of work as well. In this area, I think we're at a fascinating juncture in history, and I think that's why this project is so exciting, because there's sort of a global jigsaw puzzle of privacy and other laws regulating online advertising. And each piece of that jigsaw puzzle is changing. So, and the Australian piece of the jigsaw puzzle is no exception. As people would know, we've had the ACCC Digital Platforms Inquiry, and also the ACCC AdTech Inquiry, and privacy law reforms are expected in the very near term. So the sorts of changes which are being contemplated, I'll just quickly take you through some slides. The first one of them is in relation to the meaning of personal information. There's a real sort of range of views as to the circumstances in an ad tech environment in which information will be personal information for the purpose of the Act and therefore regulated. People spend a lot of time thinking about this decision I've got up on the slide, Privacy Commissioner and Telstra, which related to a journalist called Ben Grubb, who essentially sought from a telco all of the information about him and his phone. And the court drew a distinction between information about him and information about his device and the network. And that's led to a significant degree of doubt as to the circumstances in which information in an ad tech environment will be information about an identifiable individual. It will often depend on how much information the organisation or entity which holds the information has, and whether they can work out who the information's about easily. It'll depend on things like information barriers and other measures in place. But essentially, the ACCC has proposed, and the government supported this proposal, that we look at moving towards a GDPR position, where specifically there's a specific provision saying that that essentially personal information includes identifiers such as an identification number, an online identifier, and what that can do is it can bring IP addresses, cookies, and other online identifiers squarely into the Act, so it can remove that grey area. I think a lot of people will be thinking, well, what does that all mean for me? Because there's so much change sort of potentially happening and we don't know what it's going to look like. I think the key thing at the moment is people need to understand what they're doing and be thinking about what alternatives might be available to them, and they need to be thinking about future-proofing their practices a bit. So to the extent you can readily have better notices, more consent, you'll be future-proofing the value of your data, because it means that it'll be you'll be ready for the sorts of changes that may come into play. The privacy, the next sort of stage of the privacy reform is imminent, and in fact the report with the exposure draft legislation is expected literally at any time. It's been a little delayed. And
I've heard that for a while, Sophie. That imminent word's losing its power.
I know. And so it's not until we see that exposure draft that we're really going to understand the impact, because a lot of organisations from all over the world have expressed a view to the ACCC and about what should be done in this area. And so there are a lot of complex considerations that'll be no doubt weighing on people's minds, the people, who are working on that exposure draft. Look, and this change in regulation is coupled with a change in enforcement risk. So the proposed changes include a direct right of action for individuals, higher penalties for breach of the Privacy Act, and you'll see there that they're much higher penalties at the moment. You can have in an extreme case, a penalty of more than 2 million Australian dollars, but now we're talking about 10 or 10% of annual turnover in the last 12 months. And we've got regulators who've taken the gloves off. So the Privacy Commissioner has very expressly, sort of in 2017-18, moved from a conciliatory approach to enforcement to a much more robust approach. And we're seeing that, for example, in the proceedings against Facebook in relation to the Cambridge Analytica matter. And that's significant for those entities who are offshore too, because in that case, Facebook said, we're not subject to the Privacy Act because we're Facebook Island. And the court said, well, actually, you may carry on business in Australia and we're not going to knock these proceedings out. We're going to let them proceed so that it can later be decided on a final basis. The ACCC has also taken its gloves off, and it's got, for example, the location data case against Google, which is about the form of Google's disclosures in relation to location data. And that highlights that people need to be thinking not just about the Privacy Act, but also about Section 18 of the Australian Consumer Law when they're devising their privacy notices and thinking about their practices. They need to ask that common sense question, will consumers be misled? And then if that wasn't enough, the ACMA, which administers the Spam Act, which of course applies to email and SMS and MMS marketing. And the approach currently taken is that it's not generally thought to apply to serving ads on the web, but though there are technical issues around that, and the ACMA is also taking an enforcement approach under that legislation. So over the last 18 months, 2.1 million has been paid by businesses in relation to ACMA issued infringement notices. For example, Kogan has given an enforceable undertaking. It's paying more than $300,000 for having insufficient unsubscribed facilities. So, and we've also got the Digital Advertising Services Inquiry. That report is due on 31 August 2021. And the interim report by that inquiry noted, by the way, how critical ad tech services are for the Australian economy, that they're valued at $3.4 billion. But that really is focusing on Google's market leading position, but may lead to further regulation in terms of unfair practices provisions and also new ombudsman scheme. So very interesting time to be in this sector. Okay.
Yes, you're going to be busy. Always work for lawyers out of all of that with them. Yeah, it's going to be fascinating how they all interact and come together. I guess a question for probably Alex and Sophie. We might start with Alex Cohn even on this one, and bringing Alex into the conversation. Alex, if you don't follow him on Twitter, he's one of the most passionate and I guess philosophical ad tech thinkers in the world. So I would recommend that. He's
really,
sometimes, yeah,
really,
it's. I like watching your arcs of arguments and getting quite involved. So I think that speaks to, I guess, what I sort of said earlier, ad tech and policy and privacy coming together properly for the, feels like the first time in the last 12 months. So please give Alex a follow. I guess this follows on from everything we've said so far, but it's a little bit along the favourite child type conversation. But in terms of, I guess, either markets or commercial organisations around the world who are actually, you feel like there are being developed policies, government or other, that are a bit more future-proofed, whether that be for legislation or the one thing we probably haven't talked that much in amongst the mix, tech changes that are happening that, although maybe sort of privacy driven to an extent, are in the hands of Google's or Apple's or other people that are, sort of outside our control. So it's basically a who's doing it well, who's preparing for the future enough, Alex. And you don't have to necessarily name names, but
yeah. Well, I mean, there's different ability to do things well depending on where you sit in the ecosystem, because the real thing to me about privacy and data protection is, how and where data can be collected and then activated, right? So like used later. And we're seeing, right, that platforms like browser operators like Google, but also Apple with Safari, like browsers and then operating systems are basically, taking their position as sort of what I would call the data collection and activation surface area that makes the most sense to the user. And actually, like we were just talking about PII being related to a device ID or personal information being related to a device ID. They're in this position where they have more options of what they can do for consumers related to data protection and privacy than, let's say, if you're, I don't know, like Nine is a media company, and Nine isn't small, but it's also not like, it's definitely not small, right? But it's not sitting as a browser. It's not sitting as an operating system. So like comparing like what Google can go do in Chrome versus like what a large even media company can go do in some market, like is sort of an unfair comparison in a way. So I'm not going to try. Yeah. What I will say is that, like, if you look at both sort of approaches, the browser operating system approach is about, like, I actually call it data protection. I was on a call with one of those big platforms the other day, and I was like, you should call it data protection sandbox, not privacy sandbox, because it's not really about controls for users. It's about limiting the spray of data. And that's really what those proposals are doing. And I think, however, like, so I focus in on that because that actually is the area where I think more companies can do more about data protection. So,
Yeah.
I was on a panel actually with an Australian. This is why I mentioned Nine. It was Ben Campbell from Nine, and we were talking about publishers' desire to limit this spray of data. So there's like an incentive to do that. So that's a good practice all around. Like it's like just limiting the broad spray of data. The other thing, if you take it away from the platforms for a second, just like best practice that we're seeing among folks that aren't sitting as a browser or an operating system is really like, this is going to sound self-serving, but it's what this project is about, which is how can you make it clear to the supply chain that supports digital advertising, sort of like on a ad request by ad request basis, like what if any transparency has been shown to a user, and like if they've taken some sort of like action on that. And it, as many companies as support a given monetization sort of or ad transaction, right? Like you need something that can let each of those individual companies in the supply chain do that. So like, right, Michael's mentioned TCF. Now it goes further. It's complex in a lot of what it supports technically, because GDPR is complex. But looking at a bunch of the companies who've built, both on the like publisher and advertiser side, but also ad tech, like built their systems around being able to queue off of these signals that are sent, like, saying you don't have sort of consent for this purpose, but you might have consent for this purpose. Like that is a good practice in the sense that like you're listening for signals where they exist, which I realize in Australia it would be different today, and we'll talk about this in a little bit, like how we can bring privacy signaling to the supply chain to Australia. But that to me is huge. Is like, how can I, as a publisher, let my supply chain know what I've shown to a user, and if the user's taken any action, and then what as a vendor supporting that, media company or publisher, like what am I going to change about the data flows in my system based on that signal?
Thank you.
It's I think if I could just add a couple of things to what Alex said there. I mean, I think it's clear from what he said, there's so many key players and elements of that ecosystem that you kind of need to attack it in different ways. And I think the sort of tech giant politics is really interesting in relation to this. Anyone who drives through Sydney at the moment sees Apple, iPhone, it means privacy, and the phone is covering the person's face. So what Apple is doing with Safari and blocking cross-tab browsing and stuff. Yeah, exactly. That was you on the billboard, Alex. I knew I recognized you from somewhere. But I mean, that's really interesting. People are perhaps skeptical about what Apple is doing with, blocking that, and whether then they become the source of necessary information for advertisers, and whether it's really quite as pure as they suggest. But, that's one element of it. I think when you look at, but I come at it from a consumer perspective. And if you look at some of the consent management platforms, if you open up Facebook and you try and manage all of the consents, you are faced with a wall of sliders and jargon you don't understand necessarily and have to think about. It's sort of like the illusion of choice. It's one of those, the paradox of choice, where you're in control, but you're really not. And so I think what is key, coming back to Alex's point, is this sort of industry-driven solution. Like, we've got your online choices in Australia, you've got the global vendor list out of IAB in Europe, where effectively industry kind of takes a view and enables control in quite a sort of broad way, rather than a very granular, advertiser by advertiser or platform by platform approach, which is just exhausting and unwieldy in itself. So, again, to Alex's point, where you start to get a common language and common tools across a whole ecosystem, that's when we can get a solution that kind of works for individuals and industry and balances that efficiency because transactions are happening in real time, and we need to be sure that, you know, they're lawful and working okay within the context of the regulation, but also has sufficient acknowledgement of, you know, very valid consumer and user privacy rights.
Getting that language right for consumers is very tricky, and I don't know if anyone's really cracked it yet. Sophie, bringing you, and I guess, well, on that, you know, in terms of you, I know you work with a lot of different commercial organisations. Do you see sort of, you know, a trend to people, to organisations, I guess, improving what they're doing? And also, I don't know if you saw, there's a question that's just come through in the chat, when we talk about identifiers and PII. I guess positing, you know, from a privacy point of view, shouldn't we be trying to move away from identifiers? So I love, I guess, your real life experience today and that sort of question.
Taking each of those in turn. So yes, things have massively changed. In fact, sort of 4 years ago, for two different reasons, I had to do, for client-based reasons, I did sort of reviews of practices across I looked at two different segments, important segments of the industry, and looked at practices at that time. And at that time, the common, you know, notices were brief. There were generally terms, including website terms, which said you agree to everything. And then, you know, and the opt-outs were rare. I've had to do the same more recently in another context. And you know, and also obviously we've advised people along the way. And there's been a massive ground shift in practice over the last 3 years. So standard market practice has lifted, the extent of disclosure has massively lifted, and the extent of both opt-in and opt-out consent mechanisms has remarkably increased. And I think that has been affected by the GDPR changes and a higher consumer consciousness, but also by the change in the regulator approach, which I mentioned before. The Privacy Commissioner was quite explicit in her change of approach, and the ACCC has also been explicit through the platform's inquiry and its enforcement actions about, you know, they're very serious about enforcing in these areas. And our European colleagues, because we've got a huge European privacy team, and we're hearing from them that now there are also web crawling type technologies which are being used to identify and report en masse privacy infringements to the regulators. So there are now sort of enforcement notices sort of or complaints going in about hundreds of organisations at a time. So the enforcement and risk environment has changed, and practice has changed in accordance with that. And then the second question, wouldn't it be better if people didn't use identifiers? The effect of, I think the regulators probably agree with that person to some extent. Obviously, that's somewhere where different organisations will have very different views and perspectives. Consumers do benefit from, you know, from having nuanced information given to them. We are seeing more opt-ins and opt-outs. So I think you've got to think about identifier practices in that broader context of what's around them. It doesn't need to be the same as what's there today. It might be quite different. And you need to also be thinking about what Alex was saying about spraying out data, who's getting it, you know, and is that within consumer expectations. So the effect, if identifiers are brought within the definition of personal information, is that the Privacy Act frameworks for transparency and which limit use and disclosure of personal information will apply in relation to them. So that would probably be something that the person who asked that question would be in favour of.
Well, let's keep going, I guess, with thinking about the future for Australia, and we might bring Alex kind of into the mix in terms of, you know, if we're building something out that will work for industry. Sophie, you've sort of touched on some of the areas that you think the regulator's looking at pretty seriously. Do both of you, Alex Hutchins and Sophie, just want to talk about, I guess, where you think we might end up? And then Alex, Karen, how we can, I guess, make sure that we've got a privacy string that works for our market?
Sure. I think Sophie had a really helpful slide, which we have quite a clear idea of where it's going. The Attorney General is literally about to release a final report and draft legislation, as Sophie mentioned. And so we have some pretty good ideas about what they were looking at as part of that. And I think that slide kind of summarized them nicely. Leveling up for the digital realm is really kind of the key philosophical driver behind a lot of it. I think there have been several reports and inquiries into digital ecosystems generally, ad tech specifically, and that is just something where, while the privacy framework in Australia, being principles based, is actually remarkably flexible and has evolved quite well to match, what has been an unprecedented rate of change in commerce and e-commerce over the last 15 years. It's definitely time for some fit for purpose changes. So that's key. And I think coming out of the GDPR, the sense of personal direct right of action and enforcement to go along with that. So in Australia, there's a reasonably convoluted process to go through to actually get redress under privacy laws. It's not quite as simple as saying, you've breached my privacy and I'm going to sue you now. And so that is probably one of the key factors leading to what Sophie was talking about up till very recently, where the local market wasn't what you might think of as a hostile or highly litigated jurisdiction, because individuals didn't have clear rights to bring claims in the way they might for like a breach of contract claim or something, or consumer protection rights, which the ACCC has managed very actively. And that's an entirely different sort of regime in terms of enforcement risk. So I think that's really the key trend. We're going to see a fit for purpose in digital and much more active regulators and individuals as a result of higher enforcement and clearer enforcement rights.
Alex, Karen, and I guess Michael to an extent. So I guess looking at the changes, I imagine they're not dissimilar to other ones that you've seen around the world, and the ability to build up from a technical point of view to meet these requirements. And then on top of that, Michael, I'd love your thoughts on, Sophie mentioned, Sophie and Alex both mentioned, I guess, the amount of scrutiny that's coming in terms of complaints around the world to regulators, and the volume of complaints coming in through to regulators. I guess how that's being managed, and how as an industry we can make sure that, people are compliant. What's our role in this as an industry body and a broader industry, that we make sure we don't all seem like we're, doing the wrong thing when there's sometimes just bad actors or early misinterpretation of the law. So Alex, do you want to go first?
Yeah, sure. So there's been reference to what Tech Lab is doing, right? In relationship to the work product that's been talked about with this cross-jurisdictional privacy project. What we're working on is something that we're calling Global Privacy Platform, which really the idea is we built technical standards to support either different policies or different legal interpretations in two markets. To Michael's point before, there's going to be more, as we're already been seeing, there's more law in the books, so there's law evolving. So we've decided, right, let's build a technical standard, like underlying standard that can adapt. And in as much as the question is, can what we're building work for Australia as like in current state, but also as the law sort of evolves? The answer is yes. And that may sound like, well, that's a too good to be true answer, but that like the whole goal in building sort of a streamlined technical framework is to say it's sort of signal agnostic, in the sense that the underlying sort of tech that a company might build to is on the premise of there's probably going to be some sort of, transparency. There's probably going to be some sort of controls that are related to that transparency. And there's probably going to be some sort of concept of data uses and maybe, you know, like the CJPP lays out, maybe there's sort of granular information about companies involved or just categories of data, but the whole design of what we're doing technically can support sort of any direction the law takes. And the good thing about that, besides the fact that it's adaptable, is once you get enough companies that are operating globally, having built to this, you start getting sort of like scale network effects where, you know, a bunch of other companies want to, you know, build to support something that, you know, this actually happened in Europe. Google built to TCF. If we can get a company like Google, who's got their ad server and a lot of different publishers in your market, we can get, you know, companies like the Trade Desk, who's a popular like DSP in your market, to build to these underlying standards. You start seeing more tech companies building because they need to interoperate with those, but also like just more market participants. So yes, we're building something that will work for Australia. And then I think it's important to know that kind of once it starts catching on, like it probably spreads pretty quick, and that's a good thing, right?
And building, building on that, what Alex said about the global privacy platform, which contains the string, the way I think of it is, it's the pipe, and in those pipes, you know, are signals that are being sent between parties. And it might be communicating, yes, I did what I need to do with notice that relates to a particular purpose and obtain consent or opt out or whatever the particular requirement is. But, you know, by the way, especially when you have new laws, there are certain pieces of it which are hazy. Think right after GDPR went into effect and how everyone had a different view and understanding around the legitimate interest. And so from a technology standpoint, IAB doesn't make those kinds of determinations. If there's a colorable basis for a legal interpretation, the signal accommodates it. And so parties can make their own legal determinations about whether to accept the inventory or not. Or there's also a role for the local IABs. And I think this is a really critical part of it, because we don't, through this exercise of the CJPP legal specification spreadsheet, which will get fed into the global string, we don't actually say when you have to send the signal. I mean, there's a means to send a signal, and we don't have a requirement that says what you need to do when you receive the signal. There's two ways in the world that you can do something with that. One is by a contract with your counterparties, and the second is by having an industry mechanism where a local IAB, such as IAB Australia, creates a policy framework that industry participants sign onto, so that there's a common understanding about when to send a signal and receive the signal. Or to the extent, you know, there's an interpretation of the law that the organization says, while we're still waiting for a data protection authority to make a determination on it, we think it's prudent that we do X. And you can build that into your policy. And so, so that's really a critical component. The second piece of what you asked related to this increased enforcement around the globe, there's no question that data protection has risen as an important issue, that resources are now being allocated more than ever to build up staffs of data protection authorities, and we're seeing increased levels of it. And you know, I think one of the things that, as Australia begins its pathway down this process to revising its privacy law and increasing enforcement, is trying to pull together some of the lessons from different jurisdictions. And you know, just looking at CCPA as an example, we didn't have any, until earlier this week, we didn't have any case summaries from the AG's office about enforcement actions. And so without that, we've spent, you know, more than a year sort of doing this dance among practitioners about what we think the state of the law is in the manner in which it's enforced. And so that's really not helpful, because we do as an industry want to comply. We do want to up-level our game. So one of the lessons that you can take from our experience with CCPA is having a higher level of transparency and communication about the steps that are being taken vis-a-vis companies, because that becomes lessons for the rest of the industry to up-level themselves.
Perfect. Now we've gone over time because there's so much to talk about, and it's a really important topic, but thank you all for your time today. If there's anyone scratching their head in terms of still, what does this all mean for me right now in Australia? We do have a really, it's a short but succinct privacy essentials training that we pulled together with Salinger Privacy. So I'd highly recommend any particularly commercial people, anyone from the data side or the sales for data, undertake that. It's a couple of hours. The test is quite hard. I will warn you, if you fail once, it's fine. Take it again. It will just actually give you a grounding in where we are today. So please have a think about taking that course. Our next webinar is on sustainable marketing. So slightly different topic, but a very important one. So looking at the role of well, consumer demand for more sustainable products, sustainable processes, what that means for marketers, consumers, and our planet. So hopefully some of you can join for that. We've got some great case studies from different marketing organizations doing some really interesting things. So thank you again to my guests today. We will share the recording of this probably next Tuesday, along with the deck that Sophie pulled together. And I'm sure there'll be questions. Most of you on this call know myself or someone at the IAB team. So please shoot through any questions and we'll answer them accordingly. Thank you, team.
Thank you.
Thank you.
Thank you for having us.